Please be seated. The court is now back in session. Before I hand the floor to case upon defense to continue their closing statements in case 002/01, the trial chamber would like to remind case upon defense that the time allocation for your team is 2 days. That's for the counsel as well as for Kiel Sampond. That is for the totality for the closing statement for case 002/01. And I'd like to inquire from the Kiel Sampond's defense how much time Kiel Sampond himself will use and when is the date that he will use to present his speech. Thank you.
Monsieur le Président, il y a quelque chose.
Mr. President, I haven't quite understood something you said. It may well be that it wasn't properly translated. What I heard was that our closing arguments would last for 2 days and that in the 2 days you would set aside time for Mr. Kiel Sampond. Is that correct?
Yes, that is correct. This morning we did not clarify the time allocation for your team, and in fact that time allocation has been sent to all the parties before the start of the closing statements. And now we just try to recall that for your team, to remind your team, and we'd like to inquire from you when Kiel Sampond will make his speech, that is his oral argument for the closing statement, and when will he do it?
Well, what I do not understand is this. Is Mr. Kiel Sampond going to be treated differently from what we've seen with the other accused? Mr. Kope and his learned colleague had 2 days, and I do not see why Mr. Nunchia should be allowed half an hour, whereas we will not have that time as well. There may be a problem of communication. That is not at all what we heard, Mr. President. Let me conclude what I'm saying, please. We had understood that the parties would be allowed to respond next week. And within the time for rebuttals, the accused would be allowed to speak. But to my knowledge, I have never heard that our team or the other teams will split the time allotted to them, and some of it would be set aside for our client, Mr. Kiel Sampond. I've never heard that.
President, the time allocation today is for you, counsel, and your clients, the accused, and the totality of the time is 2 days. During the 2 days time allocation, you can freely choose when you wish to speak and when your client wishes to speak. And for the last day, then the additional time will be granted to each of the accused to make their speech, and each of the accused will be allotted 2 hours. And of course, you cannot compare your time to Nunchi's defense. Yesterday, as you have heard, Nunchi's defense said he would not use the time during the 2-day time allocation. He will do so at the last day. And that will be on the last day of the closing statements. I think it is clear to you now.
Oui, j'ai compris.
Yes, I have understood. So, Mr. Kyo Sampan will speak on the last day during the rebuttals.
Thank you. That's all we wanted to hear from you. But now you can resume at your closing argument.
Merci.
Thank you. I would now like to talk about some issues regarding evidence in this case. In our closing arguments, and I will not revisit this point again, my learned colleagues of the Nonchia defense team talked about the fact that if we look at all the documents used by the prosecution to justify their closing arguments, one may conclude that this trial could have cost only a few dozen dollars. In the evidence that has been presented to you over the past few days by the prosecution were some video excerpts. These excerpts are free of charge. They do not cost much. And these are documents that can be malleable. And let me demonstrate what I'm saying. And I would like videos 1 and 2 to be screened for me to show what I'm trying to explain.
Et vous disiez en même temps que
You were also saying that your family had been in power for since 2001. When the interests of my country command that I should step down as head of state, I wouldn't like anyone to kick me in the butt. And I was driven out, whereas I didn't betray my country. I do not accept this. That is why I fought. I fought and I won. Because I like fighting. As Cassius Clay said, if you want to engage in a boxing match, I would like to box with you. You had no power as the executive. What is your feeling vis-à-vis your people, vis-à-vis the government? Well, I am proud of being in power. I'm proud of being part of the revolution. I want my monarchy to work within the framework of this revolution, because there is no monarchy that is intelligent enough to stage this coup d'etat. I am proud that the Kingdom of Cambodia is the most progressive in the history of humanity. Do you live in the royal palace? I do not live in the royal palace. It is the Khmer Rouge who settled me there. Did you ask for that? They said a head of state should live in the royal palace, which symbolizes the state. So the head of state should live there. That is what they told me. I would content myself with. Now, talk about relations with the Khmer Rouge combatants. What do you think of the coup d'etat? Regarding the coup d'etat, relations are very good, very cordial, and full of trust. We agree on most of the points today, both at home and abroad. We have the same line of conduct we agree with one another. We agree with one another. It is the dentist sometimes with my wife. Well, I used to see people on the streets. They were coming from their factories. They were going back home, but those people did not look unhappy. Did you speak often? No, I couldn't talk. But all I did was go to the dentist with Kyo Sampan. We visited some cooperatives. We visited rice farms. We visited work sites where people were working with their hands. These people were not unhappy. They didn't look terrorized. They didn't look famished. They didn't look famished.
Two interviews, therefore, have just been screened before you. And the first interview was given in October 1975 in New York to French journalists. October 1975, precisely. Samdech Sihanouk, therefore, was traveling to New York. He was free. Nothing forced him to do anything. And the pressures that you spoke about, pressures from Pol Pot in the minutes of the Central Committee meeting of 11 March 1975, and minutes that were used by the prosecutors this week. Well, this pressure have not yet been implemented, if ever, because here we are 6 months before this meeting of the Central Committee of a Standing Committee, correct interpreter. In October 1975, during this interview, the evacuation of Phnom Penh not only had been decided already, but it was implemented and it had been completed already for quite a few months. And Samdech Sihanouk is living in an empty Phnom Penh. And beyond this, in October 1975, the events of Tulportray have already happened 6 months earlier. And finally, in October 1975, not only the second phase of the population movement has already been decided, but its implementation started. And since we do not have any certainty of when it was completed, maybe this movement was already completed. However, in this interview, Samdech Sihanouk says it clearly. I agree, he says, entirely with the internal and external policies of my country. And the second interview is dated 5 February 1979. That is to say that this interview was given after the fall of the Khmer Rouge regime. And then all doubts regarding the risks that Sihanouk may be facing may be cast aside when he speaks about what he really saw in the cooperatives. Well, no. He dares stating that the cooperatives that he visited with Kyo Sampan during the regime were filled with people who did not seem unhappy or who did not seem famished. So, of course, Mr. President, my intention is not to come up with fantasies on the basis of these videos. I only wish here to demonstrate to you and to tell you that this is the kind of evidence that the prosecutors line up against our clients. And I intend to tell you that if someone had had the daring, if somebody had dared dragging Samdech Sihanouk before this chamber, this is the kind of evidence that the prosecutors would have displayed on our screens in order to demonstrate his guilt beyond any reasonable doubt, as they say. And the other evidence that used by the prosecutors, well, in fact, very little in reality, are statements, testimonies. And we have the impression here in the defense that the prosecutor does not use very much what was said during these 2 years of trial before you here. Or maybe they used their statements to distort what the witnesses were saying. In the first day of his final submission, my colleague Victor Copé spoke about all of the pressure and all of the inherent difficulties in gathering these testimonies and in sometimes repeating these testimonies before your chamber. And beyond this, you cannot avoid keeping in mind, when you will make your decision in this case, the issue of the age of the facts. These are facts that happened a long time ago. These are facts that date back to maybe more than 38 years when we speak about what happened before 1975. Personally speaking, and maybe you might see that I am fantasizing, but now, today, at the age of 47, I am completely unable to describe to you in detail a specific event that occurred in my life between 1975 and 1979. But however, although, of course, I'm not going to belabor the point, this period was not necessarily easy for me. So, it seems to me, or it seems to us, that the original evidence in the case that you are trying today should have had a special role in this trial. They should have had a central role. However, over the past 2 years before this chamber, we have only seen 2 original documents. So, these were not minutes of the Standing Committee, which are the key documents in this case, and that we only have photocopies of. These were 2 copies of a propaganda magazine of the Khmer Rouge regime. And furthermore, for the past 2 years, I've been following as best as I can, or I've been helping as best as I can, corrects Mr. Cursampon, and I have never seen the case file. Never. I have only seen scans or partial copies. Article 86 of the Internal Rules provides that the parties may consult the case file and obtain copies of the elements. This, therefore, might mean that this case file is open to consultation, and there must be a document somewhere in it, but it seems that this document has disappeared. Nobody seems to know where this document can be found. Apparently this is a virtual file, a file that has only been approved, that only has existence through its digital form. This morning I arrived before this chamber through a door that I'm not used to going through, which is the main door, in fact, the main gate. And after having gone through security, I noticed a trophy in a showcase. And this trophy that is displayed was an award for the 2009 award for the greatest technical innovation in a trial. And I said to myself that this was probably some kind of award given for magic, an award awarding the person who made the file disappear. The file which all criminal trials in the world should have been put before you in the middle of this room and during the entire trial, thus as well as the exhibits. And whether these are claimed original documents from the period or photocopies, we would have liked to know what was the pathway of these documents until they arrived here in the virtual case file of the tribunal. Here, it seems that it is impossible. The root case file apparently has disappeared, and I have to base myself on suppositions when I receive a document or when I plead here on the basis of a document, or when I imagine myself using such and such a document. I am reduced to time-consuming research on the computer to try to understand how the investigating judges received such and such a document. Even the number of pages in the case of the investigating judges is a mystery for me. I've heard everything from 500,000 to 1 million pages. In fact, I don't know anything. I really don't know. And this cannot be verified, and this is maybe why you finally gave us so little time to try to verify this. And I remember a hearing in December 2011, during which you said, Mr. President, that the debate on the authenticity of the elements in the case file should have taken place before the closing order was issued. And I do not believe that this, in fact, is correct. I remember also a hearing in January 2012 on the objections to the admissibility of documents, during which you stated that the Chamber would consider that, or considers that, when an accused person asks to be presented the original copy of a document, this means that the accused person was using his right to remain silent. This says a lot. This says a lot regarding the difficulties that we're confronted with today. Because when an accused person is asking to be presented the original copy of a document, if this original copy can be found, he is asking for a discussion to take place on this document. And this discussion should have happened during this trial. We would have wished to have this debate for each element tendered into evidence, and not just for the main categories encompassing everything, and not only during a hearing is called hearing on key documents, which we have condemned often, because they were announced previously as destined to the public, and lawyers were forbidden from speaking until we were announced that these hearings were entirely part of the trial. So I understand that Article 87.1 of the internal rules says that the evidence is free, but the judges, may the judges in such a serious case as this one avoid asking themselves, what is the origin? What is the nature? What is the chain of custody of the documents on which the prosecutors are asking themselves to rely on to develop an intimate conviction? I don't believe so. I don't believe so, because the prosecutors are not your friends. They are asking you to give the maximum sentence to the accused person on the basis of videos, on the basis of scanned documents, on the basis of photocopies of articles in the press, on the basis of testimonies going back 30 years, and on the basis of 2 original documents. And then we are forced to note that it would be dangerous to rely on a minimum level of probity on the side of the prosecution. Let me just give you one single example today. The Nuntia team gave many, many examples, in fact, to illustrate this, and we will try to provide other examples. On 13 June 2012, via a decision indexed E166/1/4, your chamber ruled on the probative value of the statements of Professor Kiernan. And Professor Kiernan refused to work with your chamber and to come to Phnom Penh. And in your decision, you stated the following, and I quote, free translation, pursuant to the standards destined to guarantee the probity of the trial, such as established at the international level, the inability in which the chamber is placed today to call Professor Kiernan to testify implies that Professor Kiernan's findings will only have very little probative value, if not any, in case 002, given that their author cannot be cross-examined. End of quote. Do you believe that the prosecutors take into account this kind of decision? And in order to verify this, we propose to you not only to listen to them, which you did attentively, but also to look at their submissions of 538 pages, out of which 311 include 2,900 footnotes, a submission that for which you already decided that neither Kyosompa nor his lawyers could read this submission in a language that we understand, a submission that for which we were only given 18 days to try to understand something from it. And in this submission, when speaking about capital points, the theory of the prosecution is only supported by the mere writings of Professor Kiernan. And your chamber, however, had already stated that his findings have no probative value. These are three examples among many others. These are the examples that I was able to find at the last minute, in which this witness is given a key role by the prosecutors. Paragraph 521, footnote 2012. Mr. Kyosompa apparently summoned a supposed study session of 500 people. Paragraph 554, footnote 2282. Apparently, Kyosompa made statements in December 1975 to try to justify the evacuation. Paragraph 643, footnote 2795. In 1992, apparently, Mr. Kyosompa proffered threats of ethnic violence, of increased ethnic violence. Do you remember, Your Honors, the reply given by Mr. Chung Yuk, the head of DCCAM, which is an organization that is one of the key sources of documents that make up your case file, even though it may be virtual, and who before this chamber refused to reveal or to reveal to you where, in which secret locations throughout all of Cambodia, his organization kept possible original documents that it has been gathering, and of which we only received photocopies and scans. You also shall remember his answer when I asked him why we should believe him when he asserts that he has originals of the documents. And Mr. Chuk Yang then answered to us in a very serious manner, and he said that in order to decide on the authenticity of a document he received by mail, he would listen to it and he would touch it, and he made this comparison. It was almost like having a nice breakfast. I'm sorry, but I believe that we are in a court of law, that we are entitled to be very concerned of the probative value of the evidence that is discussed in this virtual case file through a chain of custody that is poorly described, that is kept secret, and on which the prosecutors and Ms. Chia Liang as well are asking you to rely on to sentence the old man, of course, maybe monstrous, to the maximum sentence. As a conclusion, and to conclude what I said this morning, I would like to recall the statements of Marcel Lemond, once the co-investigating judge here, who acknowledged in a book that describes his experience here at the ECCC, and he says that he wrote the closing order for the sake of history. For the sake of history. Those are his words. And I'm using this verb acknowledged because, finally speaking, if we look at the closing order in its totality, or if we just look at it partially, as you did through the severance, this closing order is only an imitation of a book of Mr. Short. If we look at the supposed evidence that the prosecutors tendered in, before us during their final submission, we must conclude that these 2 years of hearings haven't changed much. But a tribunal is not here to write stories. A tribunal does not have a historical function. A tribunal is not there to foster national reconciliation above all. A tribunal is there to do justice according to the rules of criminal law on the basis of irrefutable evidence. And that is all. And that would already be a lot. Thank you very much.
Condamnez-les vite.
Convict them quickly. Convict them quickly before they die. Mr. President, ladies and gentlemen in this courtroom, that is what public opinion is awaiting of you, Your Honors. That is what my learned friend there can try to say. We are no longer naive. We are aware that the donors would like the case to ply its course. We know that all that is expected of you is a guilty verdict. There is not a single person, if we are all honest, there's no one in this courtroom and outside or out of this courtroom is expecting any other judgment, any judgment other than conviction. This symbolic conviction that has been expected of this tribunal since it was established, this conviction which would give us the impression that we have achieved our objective before history, in the eyes of history. It is a paradox of international courts. The rights of the accused are put to the fore, human rights are put to the fore, but in the final analysis, what we judge is not people for their responsibility in the acts committed. It is the symbol that we seek. I have heard the prosecution argue that we will have to look at the historical context as if it was some kind of sideshow, as if it was not at the very heart of this trial. Because if we are to try history, we have to try history in its entirety. And since the historical context is important, that is where we will start. Because perhaps there are things we wouldn't like to hear. Perhaps there are things that are rather unsettling. But perhaps there are things that jolt us, and when we say them, we have a less Manichean vision of a very complex reality. We cannot content ourselves with some kind of vision which is a pattern. We have to go to the heart of things. The defense will not content itself with the official version. We will talk about things that rattle us. We'll talk about things that bother us. We must talk about things that bother everyone and that nobody dares to talk about. To be on the side of the defense means thinking differently. Mr. President, Your Honors, that is the position of the defense. And you, the judges, you must also learn to think differently. I know fully well that it's not easy to think differently in this case. There has been so much suffering, so much pain. The sufferings of the Cambodian people who came to testify before this chamber, yes. Everyone has an opinion. You, we, myself, we think that someone should pay the price. But how do you go about it? We should go beyond prejudices, biases, preconceived judgments. We have all come here with all the facilities we have, including the defense. We have all come here with our biases. And what we, the Kyo Sampan defense team, is asking of you today is to set aside all that, all these prejudices, all these biases and preconceived judgments, and to go into this trial mindful of the rules that you have put in place, case 002, to see what both sides have to say, because we cannot content ourselves with looking at the peak of the iceberg. Yes, to conduct a trial like this one means defending the accused and prosecuting the accused. And this requires that we should set aside our prejudices, our biases. Convict them quickly before they die, but on what basis? Should we, like the co-investigating judges, corroborate by all means an idea that we had before the beginning of this trial? During these 20 months of proceedings, should evidence be set aside or considered objectively? And it is true. You've been told during these 20 months of hearings, between objections that are denied, the admission of all kinds of statements, the defense has often asked itself, do we really want to hear anything other than preconceived ideas? And during this particular time, Your Honors, at this particular time, Your Honors, I think of Jacques Vergès, our learned colleague, who was a symbol of rupture defense. This rupture defense, in which a defense team in a case like that of Mr. Kyo Sampan assumes all its significance, because what is more important than breaking with received ideas and biases when you have the impression that you have already been found guilty before your trial? Yes, the voice of Jacques Vergès is missing today. We miss that voice, not only because he had the talent of a lawyer, but because he went across all these years of history, the history that is the subject of this trial today. This aspect of the historical context that is anecdotal for the prosecution, but which is at the very center of this trial today, of the facts of this case. Some people may think that the history is a sideshow. And some may think that the events that occurred between 1975 and 1979 sprung from nothing, that it is our client that caused the Cambodian people to go malnourished. There are so many accused persons who are not in the dock. Some accused persons are missing. I am not talking of Ieng Terit or Ieng Seri. We know what happened to him. We know what happened to him and his wife during this trial. I'm talking of those responsible who were in power during the DK regime. I'm talking of the authorities of the country. I'm talking of the those who were involved in the peasant revolt. I'm talking of the antagonists in the Cold War. That Cold War, which is directly linked to the Cambodian tragedy. We should add to those in the dock the American government who started the bombings. We talk of the American bombings as if it is just an anecdote. But how do you explain the famine from 1975 to 1979 without talking of those years of destruction, of random destruction? How? Well, yes, it is very simple. We have this symbol of the Khmer Rouge. Someone has to explain, someone has to pay the price. But one reality remains in this case. This ideological struggle, which is so distant from 2013 because things have changed significantly. We are thinking of the Cold War. We are thinking of the geopolitics of that region, which is at the very heart of this trial. And when, on the other side, the prosecution is ironical about the fear of Khieu Samphan, we can speak the way they do in 2013. How about the 1960s, 1970s, the struggle for independence for African and Asian countries? Let us remember that that was the reality at the time. Another irony in history, Your Honors, another irony is that today it is believed that Khieu Samphan, who was the symbolic head of state during the democratic Kampuchea regime, this symbol, ironically, is such that he is today the only one present in the dock, the only one who is physically present in this courtroom today. And Mr. President, Your Honors, don't be fooled by appearances. This solitary presence should not mislead you. He said so before the court. Khieu Samphan is not the only Khmer Rouge. He had a commitment. He had a journey which does not at all tally with what the prosecution has written. And to understand his journey, we have to look at the historical context. For us, it is not an anecdote. It is the source of the evil. Let us talk about it. Because if we want to understand what happened between 1975 and 1979, we have to talk about it. We have to talk about the realities that occurred more than 40 years ago. And we must recall, Mr. President, Your Honors, that the issue before us is precisely that. Do we want to try a man or do we want to try history? But because when you judge a man, you are judging a political system. When you look at evidence, and do you accept vague evidence or an evil center whose objective was to destroy the Cambodian people? Because this vague and malicious center, if that is what you're saying, then you are putting words in the mouths of the accused. Should we assess the evidence and testimonies fully, completely, setting aside our biases, or should we, as the prosecution has done, extract only part of that history? Our position is that we should examine everything, and because during the 20 months of the hearings, we were supposed to talk about all these documents, the millions of documents, something that was not put forward by the prosecution, but which is nevertheless the reality of this case. Yes, April 1975. We have a country that is destroyed, a country that is bankrupt. And we are talking of this evacuation. Why did it come about? This should be clearly understood. Mr. Kyosampan has always said, and he stands by what he said, that he did not participate in the decision regarding the evacuation of the 15th of April 1975. And because we are in a trial, and because we have evidence before us, and because we have heard the testimonies of witnesses, we must look at the reasons offered by the Khmer Rouge to justify the evacuation. We should consider whether there is evidence that is in favor of the defense case, this thesis. The prosecution have shoved aside the reasons provided by the Khmer Rouge. And it is very clearly understood here that when I refer to these reasons, this is not a belated defense, as the prosecution would like us to think. It is a question of analyzing what you yourselves have heard in this courtroom, what you can read in the documents on the record. These arguments were offered in the wake of questions put to witnesses who came to testify before you. Yes, there are reasons given by Nuon Chea and Pol Pot. Nuon Chea in the dock, Pol Pot, during an interview in which he explained that the evacuation was justified by the uncertainties regarding the American interventions, pockets of resistance, and the need to increase food production. And yes, we should ask the question, what was the situation on the 17th of April, 1975? Military reasons? Yes, military reasons. I have heard a lot being said, and it was repeated on numerous occasions, both by the prosecution and the civil parties. They said that fear of bombings was a pretext. And then they said there was no risk of bombing, so there was no such fear. So I am asking myself the question, Mr. President, Your Honors, since when did we consider that if a risk doesn't turn out to be the reality, we can say that the risk never existed? How can we understand, after 5 years of a war, the Lon Nol regime that had the resources, and yet it lost the war against the Khmer Rouge? Isn't there a risk that there will be reprisals? I am not the one saying it, Mr. President. These are facts presented before this chamber. On the 1st of April 1975, Samdech Sihanouk himself, in a statement, document E3/1284, denounced the scheming which he referred to as American imperialism and that of its allies in Phnom Penh. This is what he said, and I quote: "The United States think they can intimidate us by sending a helicopter, a ship Hancock, to strengthen the Okinawa helicopter carrier and numerous naval units patrolling our seas. Thousands of soldiers, of U.S. soldiers, are on board our units, ready to come to the rescue of the army of Lon Nol." The chamber will also remember witnesses who referred to the bombings of Cambodia, bombings of the Khmer Republic, not comparable with those of the United States, but they are nevertheless bombings. Do you recall what Heder said at the 11th July 2013 hearing? And I quote: "The bombings of U.S. planes had stopped during that period. However, the armed forces and the bombings of the Khmer Republic army continued, as well as shelling by the land forces of the Khmer Republic." Yes. Up until the 17th of April 1975, there was a war, and even thereafter. And in this regard, let me make one correction. War is not only shelling, as the prosecution would think. The weapons were not only between the Khmer Rouge and the Cambodians. War is war. It is not a clean war. There is no clean war. Let us remember this. Let us recall what Sidney Schamberg said. He was present in the weeks running up to the 17th of April 1975, and this is what he said regarding that dirty war, that war which had nothing clean about it. On the 11th of January 1975, he heard some noise, and he said, "The thunder woke me up, but the skies are clear. The thunder is the work of human beings. It is government planes that are dropping cluster bombs. These are anti-personnel weapons. Each projectile contains thousands of little bombs that explode in a given space and are aimed at killing as many people as possible, whereas the other bombs target specific sites." That was the first time the Khmer Republic troops were using such weapons. And these bombs also contained napalm. End of quote. These are the anti-personnel weapons, these cluster bombs. These are not Cambodian weapons. These are not the Khmer Rouge. Could we exclude the risk of such bombings? Even key witnesses of the prosecution say yes. Remember Pipun at the 31st of July 2012 hearing, this is what he said. During his testimony, reference was made to the risks regarding the bombings of Phnom Penh. That is a subject that was broached. It was said that at certain locations, bombs were used, planes were used in Siem Reap and in Sihanoukville. Were there pockets of resistance of Khmer Republic troops? Yes, there were. Can we be sure of their reaction? No, we can't. Witness Chumse said this at the 11th January 2013 hearing. And you say that it was a soldier in Lon Nol's army. Let me quote. We were moving for security reasons. We were afraid that our forces would be attacked by remnants of the army that had been conquered. Is he the only one who said so? No. Mr. Poncho at the 9th April 2013 hearing said, you call that on the 18th of April 1975, he accompanied Khmer Rouge to the Royal Palace, and you said that, and I quote, you saw Lon Nol troops resisting at that location and who opened fire. He will even testify that Khmer Rouge soldiers thought they were going to find American troops on their arrival in Phnom Penh. Rokov says, he said that they heard sporadic shooting in the town as they were in the French embassy where they sought refuge. He also talked about pockets of resistance elsewhere in Phnom Penh, and I quote, remnants of the Cambodian Air Force, remnants of the old guard that were going to continue opposing the Khmer Rouge. That is what people were afraid of. When in Battambang, some people understood the need for temporary evacuation. These are testimonies you have heard before this chamber. Yes, it is true. There were evacuations prior to those of Phnom Penh, but these were evacuations that were part of military tactics, and that is something very important, something we must bear in mind when we will have to talk about the purported responsibility of Khieu Samphan in the implementation of that evacuation, evacuations that we have spoke lengthily on the side of the prosecution. These evacuations were implemented by the military wing of the Khmer Rouge. And witnesses have appeared before this chamber to explain the ways and means of the evacuations. Witness Nikan said it was a question of evacuation a population from combat zones, and sometimes temporarily, when the civilians themselves were not fleeing on their own accord. Shukrin also testifies, and I quote, we were in wartime. We had no reason to consider all civilians as the enemy, and I had not received any orders to that effect. But if the enemies attacked us and the people had not been evacuated, that would have represented a risk, end of quote. And these statements are confirmed by witnesses used by the prosecution, witnesses such as Deutsch, Pipun. That was a guerrilla tactic that was confirmed by Chandler before this chamber, who explained the background to the combat methods used. That was during the 19 July 2012 hearing. He talked of the war tactics to come to power. He also said during the 11 July 2013 hearing, when Heder was heard, he supported what we say. These were not punitive measures taken against urban dwellers. That was the context in which the events occurred. We also talked about the reasons related to healthcare, the reasons for the evacuation related to healthcare. The prosecution has said so many things, giving the impression that only the Khmer Rouge were at war. It was clearly explained that it was because the Khmer Rouge had circled the town in the last offensive against Phnom Penh, and that the situation was critical in Phnom Penh. That is false, and I'm not the one saying so. You have the evidence before you. You have the witnesses who came to explain the influx of refugees caused by the American bombings. At the 23rd of July 2012 hearing, expert witness Chandler recalled that in April 1975, the population of Phnom Penh was between 2.5 million and against 500,000 in 1971, and that they feared the bombings by the Americans in 1973. That was well before the last offensive by the Khmer Rouge. On record, we also have the book by Michael Vickery, document E3/1757, and he says in that document, and I quote, to remain within the context of history, the historical context, it is interesting to note that the exodus, the forced exodus of the city dwellers in April 1975 was not the first event of the sort in Cambodia, but it was the first affecting the well-to-do in the cities. According to estimates, the population of Phnom Penh increased from 600,000 in 1970 to more than 2 million in 1975. But half of the increase and a higher number of the total population of the towns in 1970 consisted of peasants who had fled their lands because of bombings. And Poncho said that the refugees were fleeing from the fighting and not only from the Khmer Rouge. And I quote, as we say in Khmer, when elephants fight, it is the ants that pay the price. He is not supporting the Khmer Rouge, nor is he supporting the government. As of 1973, many people fled because of the American bombings. End of quote. And what was the situation that was prevalent in Phnom Penh in April 1975? Residents of Phnom Penh have described before this chamber what the situation was. I'm thinking of Laiboni Pexrepal Miasoran Tung Soka Al Rokov, who talked about a shortage of housing. He talked about the food shortages caused by this influx of refugees. In addition to this testimony, or these testimonies, we have documents that support what we say, document E3/4188. At the time, and we are talking about the situation in 1971, that is well before the last Khmer Rouge offensive, Dr. Muniam, Dr. Moniham, president of World Vision International, writes the following, and I quote, during this last month of fierce fighting, the population of Phnom Penh doubled. This town that had been overpopulated with its 750,000 inhabitants now had more than 1.5 million people, Cambodians who had fled the rural areas, fleeing from the cruel war, flooded Phnom Penh, looking for shelter, food, jobs, schools, and healthcare. And he adds, the overpopulation, malnutrition, and health problems caused hundreds of deaths each week. These health problems were accompanied by others, and they were referred to by many authors. Margaret Scullum in document E3/4535, William Shawcroft as well, document E3/88 in his document titled Sideshow, Nixon, Kissinger, and the Destruction of Cambodia. Shawcroft also talks about the lack of medicines imported, and this problem was already in existence before 1970. Why do we talk about this? Why do I remind you of this historical context? Because if we think that 1975, the events of 1975 sprung from nothing, we should look at the context in which the Khmer Rouge came to power. What was the historical context at the time? What was the political context at the time? We cannot isolate that period and talk about without talking about previous periods. Let us recall that document E3/4187 deals with the refugee problem. Donald Warner, in a document titled Cambodia, a peaceful people bogged down in the war. This is what he said regarding refugee centers. And I quote, refugees in refugee camps are living in inhumane conditions in Cambodia. The casino of many floors. The refugees had invaded the first 2 floors. Filth, overpopulation, and unhealthy conditions with pigs rummaging for food cause a nauseating stench, as we find in the animal pens in Chicago. Arokov also refers to this refugee camp in Cambodia, housing between 100, he says, and I quote, there are about 21,000 to 23,000 refugees living in Cambodia under miserable conditions. And Rokov also explains that those who could not live in that camp lived on the streets. And by the way, many of them were hoping that the war would come to an end so that they could go back to their villages of origin. Yes, it is true that there was some American aid sent to support the Lon Nol regime, but let us be naive. As I said, we are during the Cold War was in full swing. This aid by the Americans came with strings. They were supporting the Lon Nol regime because they were waging a war against Vietnam. It was not out of love for the neighbor. We should avoid giving the impression that they were like angels. Schoenberg came to say that this was military assistance. He confirmed during the hearings, and I quote, that the fact that Washington, the aid given by Washington over the 5 years was $2 million in terms of military assistance, and it was not humanitarian aid for refugees, end of quote. This aid, which enabled Cambodia to buy the cluster bombs that mutilated so many people in Cambodia, and we must talk about that. Yes, we must talk about that. The truth is multifaceted. And Sidney Schoenberg explains that it was only as of February 1975 that the Americans dropped food for the people and not weapons and food for the Lon Nol regime. This is not food that was given for some humane reasons. And we cannot think that after the victory of the Khmer Rouge, that aid was going to continue. Nuon Chea has reminded us before this chamber that again we are in a Cold War period. Now let us look at the economic reasons for the evacuation. Could we have swept aside these economic reasons? Could we have reduced the people to saying that they were just trying to enslave the people? I am not the one saying it. This is what transpires in the evidence. This is what those who were in Cambodia at the time have testified to. The economic situation was disastrous on the 17th of April 1975.
Mr. President, I will go further in detail regarding this economic situation. Maybe it's now time to take the lunch break.
The President, thank you, Council. The time is appropriate for lunch adjournment. The Chamber shall adjourn now and resume at 1:30 this afternoon. Security guards are instructed to bring Mr. Kyew Sampon to the holding cell downstairs and have him return to this courtroom this afternoon before 1:30. The court is now adjourned.